Hello, my name is Eric Olson, Director of HELPS. This video is going to talk about seniors in bankruptcy, when it might be necessary, when it might not be necessary. I've been an attorney now for 40 years. I founded one of the largest consumer bankruptcy firms in this nation. Probably filed over 40 to 50,000 bankruptcies. I now run a law firm that helps seniors that don't need to file bankruptcy in order to stop collector harassment. But on occasion, bankruptcy is necessary for seniors, and I want to talk about bankruptcy and how it works and when it really makes sense. There's two types of bankruptcies, Chapter 7 and Chapter 13. Chapter 7 is what people normally refer to when they talk about bankruptcy. You file some papers in federal court, you list your assets, you list your debts, you go to a hearing called a first meeting of creditors, and following the hearing after 60 days, normally you receive what's called a discharge of your debts. The debts are wiped out, and you go on with your life. A lot of seniors will go to an attorney to consult about a bankruptcy, and the attorney will tell them, well, you can file bankruptcy, but you need to understand that your Social Security, your pension, your disability, your VA benefit, whatever their income is, it's protected by federal law. It can't be taken from them or taken from you, and you don't really need to file bankruptcy because your income's protected. In fact, if you go to an attorney and he doesn't tell you that for bankruptcy, you should be aware, because that would be something that I think any reputable bankruptcy attorney should definitely tell a prospective client looking into bankruptcy. But if you don't pay your debt, obviously creditors can still call, send letters, make your life miserable that way. And for that reason, a lot of seniors turn to bankruptcy just to get the creditors off their back. Well, sometimes I've compared that to using a sledgehammer to kill a gnat. And you can do it, it'll work, but is it really necessary? Especially when you figure the cost of bankruptcy, typically at least $1,000 plus the filing fee at $335, and often quite a bit more than that, up to $2,000, depending on where you live and the type of attorney you need you go to see. So there's another type of bankruptcy called a Chapter 13. The way Chapter 13 works is you make a payment over a period of 3 to 5 years. Chapter 13 is usually filed for a couple of reasons. One is to stop a foreclosure, to pay past due income taxes, to pay past due child support, to protect an asset that's non-exempt that you would lose in a regular bankruptcy. Or sometimes a Chapter 13 is filed because a person's income is too high, or maybe they filed a Chapter 7 within a certain specified time period, and then the only other option is to file a Chapter 13 at this time. You can only file Chapter 7 once every 8 years. You can file Chapter 13 more often than that. So why does a senior need to file bankruptcy then? Well, like I said, most seniors, their income is protected. No one can do anything. But again, the creditors can call and make their life miserable. So how do you stop that? Well, there's several ways. Federal law has what's called a Fair Debt Collection Practices Act, provides that when a person sends a collector what is called a cease and desist letter, all communication by mail or phone must stop. And seniors can do that on their own. They can download a cease and desist letter from our website or anywhere on the internet. Federal law also provides that when a senior's represented or a person's represented by an attorney, collectors can no longer communicate with them. They have to communicate with the attorney, and that's what HELPS does. We represent seniors that are on protected income, typically Social Security and a pension, in order to stop collectors from contacting them, stop collector harassment. We don't turn anyone away that qualifies for our service. The cost is either free or very minimal. You can find out more about that, what we do, at www.helpsishere.org, or some more videos within this YouTube videos channel that you're on right now. So it is possible to stop collector harassment by either cease and desist letter or having an attorney like HELPS represent you so that creditors can't bother you anymore. And the way HELPS works it is we represent people on an ongoing basis, so they always have an attorney, so they never have to deal with collectors. If they get a new collection notice from a new collector, they just let us know. We send them a letter, and they have to leave them alone. They can always call us and talk to us, and we'll talk to them and assure them that there's not a problem. Now, let's talk a little bit more about how bankruptcy works and why there when there's a problem or not a problem. Okay, so every state has a list of exemptions. That's property you're allowed to keep in bankruptcy, and it varies from state to state. There are federal exemptions, although the states have to choose to adopt federal exemptions, and often they'll give the person a choice to either accept the federal exemptions or the state exemptions. You can find out the exemptions for your state by just Googling the name of your state and bankruptcy exemptions, and it'll give you a list. One of the important exemptions is what's called a homestead exemption. That's the amount of equity you can have in a home. And it varies widely between the states. Texas and Oklahoma, for example, it's unlimited. Arizona and Florida have very generous homestead exemptions. And then some states like Pennsylvania or Maryland have very minimal homestead exemptions. So if you had a large equity in a home and you filed a bankruptcy in a state where, well, let's give an example. If you owe $100,000 and the home is worth $200,000, and you have a state where the homestead exemption is $50,000, then you've got $50,000 in equity over and above the homestead, because you take 200 minus 100, 50,000 homestead, there's another 50,000. So if you filed a regular bankruptcy, a trustee would say, hey, I'm going to list this home for sale. I'm going to sell it. I'm going to give you your $50,000 for your homestead, but the rest of the money I get from the sale of the home, $50,000, or if it's less than that, I'm going to use that to pay your creditors. A lot of seniors don't want that to happen, so that would be a reason not to file a bankruptcy. But an attorney might say, well, you can file what's called a Chapter 13 bankruptcy. Under a Chapter 13, if you have some non-exempt equity in property, as long as you propose to pay that to your creditors in the Chapter 13 plan over a period of time, then you get to keep the property. But let's go on with that example. If you had to pay $50,000 back to your creditors, in addition, you have to pay the attorney a fee, and usually that's paid through the Chapter 13 plan, and the trustee a commission. You could easily have $60,000 in debt to pay back over as long as 60 months. Well, $60,000 divided by 60 is $1,000 a month. If your income is $2,500 a month and you got a $750 house payment, and then you add $1,000 to the trustee, you could find yourself living off of $750 a month, which you obviously could not do. So what do you do if you owe debt and you've got equity in your home over and above the homestead exemption? You can't file Chapter 7. If you file 13, you round up with a payment you can't afford. I always tell people that generally, well, almost universally, unsecured creditors, like a credit card, for example, that sues a senior or any person and gets a judgment against them, that becomes a lien on the real property. That means the home and land that they own. But the lien is called a non-consensual lien. In other words, it's different than a mortgage. It's a judgment lien. And that creditor will never take steps to execute or try to foreclose on a person's home based on a non-consensual judgment lien. It just doesn't happen. There are procedures for it to happen in certain cases, but in 40 years I've seen that happen on less than 2 or 3 cases. It just doesn't happen. The creditor is happy to let that judgment sit there and be a lien, and hopefully they're hoping they get paid at some point when the home is sold or refinanced or at some point in the future. So seniors generally have no reason whatsoever to worry about a judgment lien as being a risk of them losing their home, no matter how much equity they have. Okay, and that would, so to file a bankruptcy just because there's a judgment lien, to put yourself into utter poverty to make that payment to a bankruptcy trustee, probably doesn't make sense. The only one that's going to benefit is your creditors and the attorney getting the attorney fees, and you're going to be the one left in a really, really tight spot. So what other reasons could a senior consider filing bankruptcy? Sometimes an attorney will say you need to file bankruptcy to wipe out your debt so you can leave your heirs some money. Otherwise, when you die, before your heirs get paid, your kids get anything from your estate, your debts have to be paid. And that's true. But for a lot of seniors, they have minimal assets, they don't have a home, or they have very little equity in their home. A lot of them don't care if their creditors get paid. A lot of them can't afford to file bankruptcy. And Also, I should point out that nearly half of seniors, before they pass, they're on Medicaid, which means the government has a lien on their assets to pay for their costs of their care before they pass on. So, a senior might find that, they're not going to have an estate anyway for various reasons. So that sums up, bankruptcy and when it makes sense and when it doesn't make sense. I it's kind of an individual choice. I would say that you can study some more. There's some more articles on our website, www.helpsushere.org. Sometimes I'll tell people that, people always give advice within the area of their expertise, and therefore sometimes the bankruptcy attorney's answer to every single financial problem is bankruptcy, when in fact there may be some other answers. The bottom line is for seniors that their income is protected, can't be taken from them. Okay, and I've already explained that even if they get a judgment against them and they have an equity in their home over and above the homestead, it's not a risk. The creditor isn't going to file any foreclosure proceedings to take the home back. Senior also has an option of filing bankruptcy at some point in the future if they want. It's very difficult, if not nearly impossible, to file bankruptcy on your own. In 2004, the bankruptcy rules were changed, made it much more complicated. So that's not usually a good idea. If you want to find out more about bankruptcy, make sure you contact an attorney that's done a lot of bankruptcies, probably someone that specializes in bankruptcy. You can look at their website and see if they do a lot of them. And I think one key is if they tell you, hey, by the way, you should know that your income is protected. If they tell you that, then they're being honest with you. And not that they're going to be, attorneys will be dishonest, but I think that's important, that you be informed of all your rights and that your income is safe and can't be taken from you. So that's it. Helps. We don't file bankruptcy for people. Our clients don't need to file bankruptcy. On occasion, when they call us, we'll refer them to someone to file bankruptcy. We don't get paid for that. We'll try to find them an attorney that will do it at a discounted price if we can do that. But like I said, for most seniors, they don't need to file bankruptcy. Now, sometimes a senior thinks they need to file bankruptcy because of their credit. Usually not so. If you file bankruptcy, your credit's going to tank. It'll probably take you 3 or 4 years to get an unsecured Visa or MasterCard. And even if you have a card that you owe nothing on or a very small balance and you choose not to list it, which you're supposed to list everything, it's still going to be wiped out because the credit card companies all subscribe to a service that lets them know when someone files bankruptcy. So your credit's going to be shot. With helps, you only list the creditors you don't want to pay. And so a lot of people do keep a credit card with a smaller balance and keep paying on it. And they can keep it as long as it's not affiliate. That bank isn't affiliated with a bank that they're not paying a credit card. They're not paying a debt on. So just to file bankruptcy to reestablish your credit, not always a good idea. Another reason is in 2008 with the Great Recession, creditors rely now as much on income or more on income than they ever did before. And if your income is fairly small, even if you had perfect credit, they're not going to give you a credit card, or they're not going to extend credit to you because they'll say, well, gee, this person's only making this amount of money the time they pay for their housing, food, utilities, basic needs. They have very little money left over. They're not going to be able to pay our debt. So sometimes people file bankruptcy thinking it's going to make it magical for them to get their credit back and be able to borrow a bunch of money, and the answer is no. It's not going to happen. So hopefully this has been helpful for you. You're welcome to call Helps at any point to ask us questions about your situation. Again, we don't turn anyone away. Toll free 855-435-7787. You have a great day.